otherwise known as Area 57, Book 25, sometimes abbreviated as 57-25. Welcome to the public meeting. We'll just go ahead and cover our agenda, talk about some of the rules of engagement here. I'm happy to answer any questions throughout the course of this presentation. If there's a question you have that's specific to your situation, I just ask maybe hold off. I'll try to answer it, but if it's kind of going down a rabbit hole, I might ask you just to either hold off and wait till after the presentation, or you can step outside and one of my assistants can help you. Some of my assistants are Ashley Ostraff in the back. She's the actual team leader. Say hi, Ashley. Gary Brimley over here in the other door. He is the kind of my deputy. And then there's a couple other personnel that will be out in the hallway. If you have a question that you just want to talk through, feel free to step out at any time and go engage them in the hallway, and they can probably answer your question if you don't want to wait and go throughout the entire presentation. One thing I like to state up front as well is I know you all received a notice that had a summons with it. Sometimes people construe that summons to mean that you're obligated to be here at this public meeting. That's not the case. This is a legal proceeding, but this public meeting is optional. You're welcome to attend, not attend. We're also recording it, so if you want to review later what has been said tonight, is on our website, and we'll give you that address. For those of you who might be tuning in at home online, if you have questions throughout tonight's presentation, that big email address at the base of the slide there, if you want to email your question at the conclusion of the presentation, I will read those questions aloud and answer them for the benefit of the group as well as yourself at home. That way we can all be edified by whatever questions you have. And if you don't get it in time, still send me the question and I'll respond to you probably tomorrow morning. This is the agenda. We're going to talk about the adjudication, what it is, kind of going over an overview. We'll talk about what a proposed determination is. That's another word or phrase you'll hear often. We'll talk about some of the significant issues and the anticipated timeline. And then, again, questions throughout, but I do have some time reserved at the end for questions. And I'll stay here as long as you guys want to stay here tonight and answer questions. So if you feel like you just have a complex issue that needs to be resolved in some one-on-one time, I'm happy to stay here and try to help you get some resolution to that. So with that said, let's get started. All right. So, you know, a lot of people who receive these notices have never heard of the concept of adjudication, and I haven't even heard of what a water right is. So I often like to kind of give an introduction to water rights, or Water Rights 101, and kind of explain what the difference between a water right is versus a water share versus what you may consider as your public or your private municipal connection. You know, what comes to your water meter, what you pay your water supplier for, your monthly bill. Well, a water right is really, it's a right to divert water from a natural source, such as a stream, a spring, a well, those types of things, and beneficially use the water. It's characterized by a couple different elements. It has a defined nature of beneficial use. In Utah, water right, the basis, limit, and measure of a water right is its beneficial use. So when we talk about a water right for irrigation, we often quantify that by the number of acres being irrigated. So when we talk about beneficial use, we're saying, what is that water being used for? Is it being used for irrigation? Is it being used for domestic use? Is it being used for stock watering? So there's a whole host of different uses for which water is used, but that use is what we quantify the water right by. We have a priority date, and the priority date pretty much tells you where in line you are to get your water. The state of Utah and most of the western United States operates off the system of prior appropriation. Back east, where water is plentiful, if you live next to a stream or a spring, you can take the water because there's plenty of it. In the arid west, we don't have that luxury, and so we have this concept of appropriation, and it kind of goes along the same lines as a mining claim, where the first in time is the first in right. And so a priority date identifies where you are in that line of seniority, whether you get your right before someone gets theirs, okay? And we'll talk a little bit more about that. As a defined quantity of water, we typically measure that in either a flow rate, which would be a cubic feet per second, or CFS, sometimes quantified, or sometimes the old timers will call it a second foot, or an annual volume of water diverted, as in acre foot volume. So that's, if you think of a yard that's maybe an acre in dimension, an acre yard, and 1 foot of water deep, that's how much an acre foot it is. Pretty self-explanatory. We also have a specified point of diversion. That sounds complicated, but that's really just where the water leaves the natural source. So if it's for an underground source, the point of diversion is the well. If it's for a stream, the point of diversion is the diverting works, or the head gate off the stream. If it's for a spring, it's the spring box. So that's pretty much just a fancy word for where the water comes from. And then a specified place of beneficial use, another kind of fancy term, which means where are you using it. And we identify that using the Public Land Survey System, sometimes abbreviated PLS. And that is just a way, a datum and a series of measurements that we go through, and I'll explain that later if you're really interested to know about the origins of the PLS and how we quantify that or we measure that. So a lot of the calls we get when we send these notices out are, how do I know if I have a water right? And that's a valid question. Sometimes water rights may be evidenced by the existence of wells on your property or a spring box. There might be ditches and head gates. Those are indications that there's a water right associated with that. Now, whether that water right belongs to you or not is another question. But those are some things that may be evidence of it. You can see some typical examples of wells that you see. This is what a head gate looks like. And the spring box just looks like a big vault, and it has water coming out of it. Sometimes that vault will collect the water, and then it'll be piped to a house or whatever it's being used for. So let's talk about what a water right is not. Although this is a point of confusion, often heard is, the difference between a water share and a water right. So a share is a share in a company, and the company owns the water rights. So if I'm some irrigation company, I'm the Bingham Irrigation Company, I own these water rights, and then what I do is I go and sell shares to these to different water users or shareholders, and they can use the water rights. So they don't own the water rights, but they have a vested interest in using that water from that water right. And so how that applies to people who are shareholders means that you have an interest in this process, but you won't be participating directly by filing a claim on your shares, except for in certain circumstances. The company itself is responsible for filing a claim and participating on behalf of its shareholders. Now, often in Salt Lake Valley or in rural areas, these irrigation companies aren't very robust. They don't have a lot of people who dedicate their lives to doing irrigation company stuff. They're busy doing other stuff. And so it's really important for shareholders to make sure that the board is tracking this and is participating in this effort. So that's one thing a water user or a shareholder can participate in this process, making sure that the board or the company, the president of the company, is apprised of this process and is actively participating to protect your shares. And it's not a connection to a public water supplier. That's the culinary connection that you see coming through your water meter. Again, that's different. The public water supplier in this case owns the water rights, but then they just provide the service to you as a commodity, okay? And so again, they will be participating in this process and filing claims on those rights that they have. All right, so often when I do these presentations, actually all the time when I do these presentations, it's helpful to give a little bit of historical context so you understand why we do this general adjudication, why you receive the summons, why am I stirring the pot, why am I kicking the hornet's nest, whatever you want to call it. And so this will help everyone kind of get on the same sheet of music. So you'll forgive me for the brief history lesson, but I think it will be helpful, and I'll make it quick and painless, and maybe at the end of the day we'll all learn something. So let's go ahead and start off with a story we probably all know about. Brigham Young and the Advance Party of Mormon Pioneers entered the valley July 23rd, 1847, started diverting the waters of what we now know as City Creek just to soften up the ground so they could actually plow in it, plant a late season crop of corn, so they had something to harvest later on. Then they built their shopping mall on top of it. Later, so about a year later, Brigham Young kind of made this statement, and this has kind of been the basis for how Utah water law has operated ever since, that that there shall be no private ownership of the streams that come out of the canyons. These belong to the people, all the people. Often when people think of water rights or these types of things, they think that the state owns the water and they're divvying out. And in truth, it's a resource owned by the public. Waters, and that's codified in statute, that it's really just a resource. The division of water rights just helps the equitable distribution of whatever rights people have. We don't own it. We don't grant or deny those rights. We simply process any applications. Well, between 1847 and 1850, what we now know as Utah is actually went through a couple different elements of government, right? So when the Mormon pioneers came here, they were actually part of Mexico, okay? And then eventually they applied the Treaty of Guadalupe, I want to say, I cannot remember the exact treaty, made it a part of the United States. And so Brigham Young thought, well, let's apply for statehood. So they came up with this kind of quasi religious state known as the state of Deseret, and then eventually it became the territory of Utah. Well, the thing is, even though it went through those different phases, the church kind of ran the show, right? They filled that vacuum because there hadn't been federal officers appointed. There wasn't really a system of government in place, so the LDS Church kind of ran the show. As a result of that, the diversion of waters were kind of done on a communal basis for the immediate needs of the settlers, Brigham Young or whomever would send a party of settlers up north, down south, wherever, and they start digging ditches and diverting waters from the streams and planting crops, okay? And they kind of did this as a community, and they shared in the shortages and in everything else. Well, as a result of this, you can imagine the first settlers came in, did all the work, dug all the ditches, did all the work to divert the water, and so they had what was called a primary right. And then you'd have other settlers who come in later, and the Mormon pioneers trying to help their brothers and sisters out would say, well, you know, we did all this work, but we want you to be able to partake of some of the fruits of our labor, so we're going to give you a secondary right. And so what that did is whatever water had been appropriated was still appropriated, so they had the senior right, and then whatever's left over, the subsequent settlers were able to get to use on their own fields. And so this concept of priority really started to evolve from there, and then it kind of became a hybrid of the mining claim priority system where you actually have a date. But this concept of primary and secondary rights really started in Utah and then kind of went from there all over the arid West. Because the church was kind of the power structure, conflicts were settled through ecclesiastical channels. You had the bishop's courts, which were kind of the initial courts. If people didn't like how things were settled, they'd go complain to the bishop. And if they didn't like what the bishop had to say, then they'd take it to the stake high council, and the stake high council would kind of act as like an appellate court and overrule the bishop and those types of things. And that's the system that they used, and because they didn't really have anything else in place at this point. Well, as we transitioned into the territorial era, 1852, the first territorial legislative assembly was in an attempt to kind of pull the power away from the LDS Church and give it back into the customary people who should be in charge, the courts and the towns and the different municipalities. They made a law that said, hey, any disbursements of timbers or waters or anything, that has to go through the county court. And it was generally disregarded for the most part. And even if it wasn't disregarded, the county courts, the judges to those courts were elected. So you can imagine who were elected to those positions, right? It was the bishops, it was the stake president. So whether they went through the bishop's court and the stake high council or went to the county court, it was pretty much the same decision. And so there wasn't really much change in how water rights were administered. Well, later on, 1877, the Desert Land Act was passed by the United States Congress. And there's a couple of things that developed as a result of that. First of all, it severed title of the water from the land. You remember back east, if you lived close to a river, you could just take water from that river. Well, this kind of recognized the fact that there wasn't enough water to go around, and so you could homestead an area that was far away from a river, and you'd have to divert water and apply it to that homestead. Another consequence of this act was that it delegated the responsibility or the authority to the local territory or the state for administering water rights. And we look back on this now and we think, well, of course, that makes perfect sense. But if you think about how federal lands were administered back then, and still today, the Government Land Office, the GLO, was still the primary agency responsible for issuing patents on land. So you could easily think that, well, water would follow the same suit. Well, this was a huge move away from that concept, and now the states were responsible for issuing water rights and those types of things. So it was a big deal. In 1880, due to the failure of the courts, the Legislative Assembly attempted to give power to these county selectmen to issue certificates and take care of and even make judgments on water rights. But that was eventually, again, no one ever paid attention, maybe in Salt Lake County, but it wasn't enforced. And then they eventually figured it was not constitutional because property rights is kind of the purview of the judicial branch, right? Not so much the executive branch. And so this is kind of the executive branch, executive overreach is the term you hear a lot these days, right? So that was kind of their version of it back then. And so they figured, that's no good. And it was ruled unconstitutional, but they weren't doing it anyway, so it wasn't a big deal. As a result of this, confusion continued to exist in spite of the efforts of the territorial legislature or even the LDS Church. And the church continued to administer and decree water rights, believe it or not. A classic example of this is the Spanish Fork River, which was initially decreed by the State High Council, and they simply split it up amongst different water companies at the time, and that's largely how that river is continued to be distributed. There have been subsequent decrees that have kind of fine-tuned that, but for the most part, that High Council decision shaped how that river was separated and distributed among the different companies. Well, in 1896, Utah gained statehood. At the time of this development, there was a lot of concern that the state was going to confiscate everyone's water rights and not recognize anyone's ability to use water that they'd relied on up to this point. And there was a lot of controversy, so they decided to say, well, fine, we won't deal with it now. The only thing we're going to deal with, we're not going to make a law on how to administer water. We're not going to do anything. All we're going to do is write into the Constitution that all existing rights to the use of any of the waters of this state for any useful or beneficial purposes are hereby recognized and confirmed. So that has kind of said, hey, if you've been using water, you're grandfathered in. You have nothing to worry about. And so it was important enough that they stuck it into the Utah Constitution under Article 17. Where it continues to reside. In 1897, 1 year later, the Office of the State Engineer, what we now know as the Division of Water Rights, was organized. And he was really just given the job of mapping the state, mapping these rivers, these systems. However, if you really wanted to appropriate a water right, you still had to kind of go in the old-fashioned way and go stake your claim, kind of like a mining claim. You go stake it at the point of diversion, then you go record it at the courthouse or in the post office. Again, largely ignored. In 1902, the United States Reclamation Service, what we now know as the Bureau of Reclamation, established, they were established to reclaim the arid West. And how they do that is they would come into a place and they build gigantic reservoirs. And they do this in order to allow farmers to use that water, which would otherwise run downstream into the Great Salt Lake or wherever, to use that water to irrigate their fields and have a more reliable source. But they refused to do this, to build these big reservoirs in any state that didn't have some type of water law that told them how water rights should be appropriated and administered. And so Utah was in that category, right? They hadn't developed any water law. They were just kind of still doing the old thing. They had no way to figure out who had these old rights, how to do new rights. Because the last thing the Bureau wanted to do was to come in here, build a big project, and then find out that all the rights to use that water they planned on using to build the reservoir were already appropriated to somebody else, because they had been here for 50 years already. So it's no coincidence that in 1903, the state of Utah made their first attempt at a comprehensive water law, which provided for all of the existing rights. Remember, all these rights that had already been under use, for recording those, adjudicating them before the court. and appropriating new water rights. However, in classic fashion of legislatures, they failed to provide any funding for this requirement they gave. And another thing is they kind of just said, hey, courts, this is the law. We're going to let you adjudicate these water rights. And the court said, great, but in a judicial system, you really need someone, you need a plaintiff and a defendant, right? A judge just doesn't go out looking to solve cases. The cases come to him. And so this system really didn't lend to that. There was no plaintiff, there was no defendant, and so there was no way to really adjudicate water rights unless there was a case that came before the respective judge. So it kind of failed. It didn't really do anything. There was no water rights adjudicated. Well, in 1919, the legislature finally figured it out and said, hey, what we'll do is we'll get the state engineer to go around, and he'll go in and do an investigation, and he'll try to find these water rights. He'll look for beneficial use. He'll require people to file claims, and then he'll make a determination that he'll then submit to the court. And then the court has something in front of them. They have this lawsuit. They have something to rule on, and the court can make a decision one way or another. And so that recommendation that the state engineer makes is called the proposed determination. And this is largely how we operate today, and that is largely how the evolution of what began as these unknown rights to where we are today, where we appropriate new rights, and we're also looking to see what existing rights are still there, some of these grandfathered rights. So in 1903, that law was only for surface waters. They still allowed you to drill a well without getting a water right or anything like that. They kind of thought, hey, surface water and groundwater, two different types of waters. Whether they believe that or not is not clear, but in 1935, they finally realized that groundwater and surface water is all the same water. They're hydrologically connected. You can't impact one without impacting the others. And so the legislature required that groundwater needed to be appropriated. So prior to 1903, you didn't need a water right to divert surface or groundwater. After 1903, you needed a water right to divert surface waters. Prior to 1935, you didn't need a water right to drill a well. After 1935, you did. So these are two kind of threshold timelines that rights existed without being on record. And after that happened, we're trying to get those old rights and bring them onto the record, which is one of the reasons we do adjudication, as well as some others, and I'll get to here shortly. So the historical case for adjudication. Prior to the enactment of the 1903 law, water rights were kind of split up into a combination of 5 different categories. There were those that were decreed by ecclesiastical leaders. The Spanish Fork River, classic example, but there's plenty of them, trust me. There was claims that were filed for record in the county court. That would be like those who had went and staked their claim and then went and go and filed it, or they went to the county selectmen, filed something. You had those that were decreed by a court, but what would happen is Farmer A would get mad at Farmer B, and they'd go take each other to court, and then the judge would settle it between Farmer A and Farmer B. Never mind Farmer C, D, E, and F, who are also on that river. He didn't decide any rights between those, because in a court case, the judge can only make a ruling with respect to the parties who have been joined in the proceeding. So in these cases, although the court made a decree, it was only limited to the parties who were joined in the actual suit and didn't go to everyone else who may have been on the river system, so they are limited. There are contracts or agreements among limited parties. Those are a lot of, in Salt Lake City, there's a lot of those where Salt Lake City made contracts or exchange agreements with people who owned fresh canyon waters. Salt Lake City said, hey, we really like that canyon water. We'll give you this awesome Utah lake water to irrigate with if you just give us your pristine, clean canyon water so we can treat it and it'll be more easy to treat and better suited for consumption, right? So there are a lot of those types of agreements between Salt Lake City and various water users along the Wasatch Front. And then lastly, there's claims that are never manifested on any record. These are those grandfathered rights, whether they be prior to 1903 for surface rights or prior to 1935 for underground rights. All right, people were just doing their own thing, and they had every right to do that. By the Utah Constitution, they had vested rights, and they could continue to do so, and so they had no reason to file a claim. And so we never knew about them. We don't know where they are, if they exist or not. So, as a result, the lack of that water law created a number of issues. First, there was no public record of all these water rights. There certainly wasn't a consolidated public record where you could go to one place and find out about the water rights on the Jordan River or the water rights on the Spanish Fork River. You couldn't go to one place. You'd have to go to the respective courthouses or the county recorders. And even then, it was doubtful that you would actually find anything because the county recorder didn't know where to put this stuff. And they're not typical land records. Since there was no record, there was a lot of over-appropriation. You'd have judges decreeing water rights for several times the flow that was found in the individual rivers. That was pretty common. And because they weren't defined, there was a lot of controversy, and they had to be settled by either the church or through the courts or other means, or sometimes just by a guy with a shovel beating up the other guy with the shovel, I guess. So in his biennial report back around the turn of the century, one of the first state engineers made the following observation. He said, "The definition of existing rights," meaning those rights that had been happening up to that point, "appears to be of first importance. This is not only necessary to pacify present contention, but to prevent future conflicts and encourage further progress. There can be no safe basis for future work before existing rights are known and made a public record." So the idea was, what we'll do is we'll figure out all these old rights, and once we got those figured out, we'll start appropriating new water rights. Well, they got tired of the state legislature not funding everything, not working, so they said, forget about it, we're just going to start appropriating new water rights, and we'll fix this as we go along. And so that's kind of what we have now. We have these two parallel tracks. We have new appropriations, and we have adjudication, trying to figure out all the old rights, and the appropriations issuing new water rights. And that's largely where we are today, trying to get caught up with that. So what is a general stream adjudication or general adjudication, general water rights adjudication? As the name implies, it's an action in state district court. So it's a legal action, which is why the summons is required by the statute. So we're all joined parties in this action. It binds all water users, including the state engineer, in this action. So remember how certain court actions were just among limited parties. Well, this is for all parties. This includes everyone. That's the title of Utah code that it's governed by, Title 73, Chapter 4. The first general adjudications took place in the 20s. You'll recall in 1919, that's when they figured out how they were going to do this, do the proposed determination, all that. Well, that's why you have certain adjudications, like the Weber River drainage started in 1919 and was completed. It actually got completed. The Sevier River got completed. Even the Virgin River got completed. So those were the initial ones to get completed. But back then, you had to pay a fee in order to participate in the adjudication, and then the state engineer would use that money that he collected from fees and start the new one. However, people didn't pay their fees. Also, the courts said it was illegal to charge a fee to exercise a right, which obviously it is. And so the adjudication process kind of languished. So you don't see a whole lot more after the Weber, the Sevier, and the Virgin from getting started until some 25 years later. And we'll get into why that is. But each of these colored little blobs on the state of Utah is a different general adjudication. The adjudication that we're talking about tonight is the Willow Creek subdivision of the Utah Lake Jordan River general adjudication. And that started back in the 40s, actually started a little bit before that, the 30s. It started because Salt Lake City sued a bunch of people on the Jordan River, like thousands plus, right? Like 2,000 people, because they're pumping illegally out of the Jordan River. There's a huge drought. Salt Lake City didn't like that for obvious reasons. They sued them. The court said, hey, there's a process to do this. It's called the general adjudication. So the court turned the private suit into the general adjudication, and that happened in 1944, which is why that date. And we are still doing that same court case. As a matter of fact, on your little summons that you receive, that the first number in the civil number, 36, that represents the year 1936. That's when this adjudication began. It's actually the oldest civil case in the state of Utah, if you can believe that. But it's undergoing. So the Willow Creek subdivision is just the tiny bite of this. Back when they did the Weber and the Sevier and the Virgin, that was back during the Depression. So they had all kinds of people unemployed, willing to work. You had the Civilian Conservation Corps that would help out with this. And so they were able to do the the basin in one fell swoop, whereas these days we have a lot of water rights, especially in this area. We have to do it in bite-sized pieces. We got to eat the elephant one bite at a time. So this is the Willow Creek bite of the Utah Lake Jordan River general adjudication. And you can see it goes up into Heber, goes all the way down southern Utah Valley, and of course into Salt Lake Valley. All right, so why do we conduct a general adjudication? We want to bring all of those claims onto the permanent record. Remember this guy? Surface waters prior to 1903, underground water claims prior to 1935. Sometimes we just lump those into the term pre-statutory claims or even just diligence claims, sometimes what they're called. Another thing that many people don't know about, it's kind of a peculiarity about water law in the United States, is this thing called Federal Reserved water rights. Now, this has nothing to do with the Federal Reserve, printing money and that type of stuff. These are for water rights that were reserved by the federal government for pieces of property that have been taken out of the public domain. And how it started is back at the turn of the century, the Fort Belknap Indian Reservation. Obviously, there were Indians there. They were trying to become the agricultural people that I guess Congress envisioned they should become by putting them on this reservation. And so they went to the equivalent of Montana state engineers and said, hey, we need to divert some water out of the Milk River so we can irrigate our crops. And the state engineer said, tough luck, Chuck. They've already been all appropriated by white settlers around you. Sorry. And obviously, they didn't like that answer, so they took him to court. The Supreme Court ruled that by virtue of the fact that Congress had taken the reservation out of the public domain, had reserved it from the public domain, that there was an implied water right for that reservation, with a priority equal to the date of the reservation. So what does that mean to Utah? Well, obviously we have a few Indian reservations in the state of Utah, so that applies to those, but it also applies to other federal reservations, Forest Service reservations, military reservations, national monuments, national parks. All of these things that Congress has removed from the public domain has an implied water right. Now you ask, what is that water right? Well, that's the great thing is the federal government said, well, it is whatever we want it to be, and you can't sue us because we got federal sovereign immunity, so tough. And it was really a pain for us to figure out how to control and how to administer our water rights if we had these huge looming potential liabilities of water rights in the Forest Service. I mean, you think of Utah owned by about 60% of the state of Utah is owned by the federal government, right? Or more, probably. I think it's 70%. And a lot of it's Forest Service. So you can imagine that there's this pending liability. Well, that was pretty common throughout the West. And so there was a senator by the name of McCarran from Nevada. He said, well, that's really unfair and kind of dumb. We need to know what these water rights are for us to act as states and to appropriate these waters. So he passed what's called the McCarran Amendment, which in essence waives the federal sovereign immunity for purposes of water rights adjudications, meaning the state can sue the federal government and force them to submit their claims and can quantify those claims so that we know what those rights are moving forward. And not only that, we can do it in state district court rather than in a federal court, which is a pretty unique thing for those of you familiar with the court system. You usually don't get away with suing the federal government in state court, right? Well, in this instance we do, and I don't know of any other instance where that's the case, but it's kind of cool. So this forces the federal government to play ball, to file their claims, and then us at the Division of Water Rights gets to evaluate those claims and make a recommendation to the court as to what we think, whether they're valid, and to what extent we think they're valid. Another reason we want to do this is we want to prevent a multiplicity of suits. We don't want people going around suing everybody. We just want to do it in one big lawsuit. Okay, so here's the controversial part, and usually I bring this up, and then the questions, like the floodgates open up, and everyone asks a question. Or one person will ask a question, and everyone will realize, oh, it's okay to ask questions. One thing in the Western states, which is pretty common, is this concept of use it or lose it. You know, the fairest way to operate or administer water rights is to give everyone the water that they need. However, that exceeds our ability, exceeds the amount of water we have, right? We have this much need and this much true wet water. And so our forefathers felt like it was important to say, hey, if you're not going to use your water, then it needs to be used by someone else. It needs to revert back to the public so someone else can use it. So in Utah, if you don't use your water rights for a period of 7 years or more, it's subject to being forfeited, okay? Meaning the court says, all right, you no longer have a water right. Next man up gets the water, okay? And you say, well, that's unfair. And I can understand and I empathize with why that, because there aren't many property rights that are like that, where like if I left my field, my home dormant, it's still mine, right? It doesn't just get forfeited to everyone else. Well, water rights are kind of a little bit different, and they're a usufructuary right, meaning you don't own the water, you own a right to divert the water, and that right is, subject to forfeiture by the courts. In order to prevent monopolies, what they were worried about is big entities, big irrigation companies, or even municipalities getting all the water and then forcing you to come to them in order to get a piece of that water. And they're always also worried, obviously, about incentivizing people to put their water to beneficial use. But if you think about it, if you own a water right and you stop using that water continues downstream and it gets used by someone else. As a matter of fact, it probably gets used by someone else, and it probably has led to a development of a community of houses or something like that. So you can imagine how traumatic it is when someone has not used a water right or used their water for 50 years. Communities have been built on this. Other people have become reliant on this water. Then suddenly you jump back in and back into your property and start taking that water, and all these people who have become reliant on that are now made to suffer. So that was another reason why the legislature decided to incorporate this as well, and you'll find this in most states, this concept of use it or lose it. It's just to ensure the best use of the limited resources we have. We want to obtain final comprehensive decrees on all water rights. So usually when people appropriate a water right or apply for a water right, they'll go through this process, which ultimately ends up in a certificate being issued for the applicant. And that certificate's pretty good, but it's not as good as a decree. A certificate just says, you are assumed to have a right. It's the prima facie evidence of your right to use that water. But a decreed right is an actual bona fide right. So it's just a little bit better, although there's a hard to find the distinction between the two. So the ultimate objective of this is to get decrees on all existing water rights so that they're solid gold. Okay, man, no questions. You guys are a quiet bunch. So we sent out 12,000 invitations to this public meeting. How many people showed up. I think as the further we go south, the less people want to deal with traffic to come in. All right, let's cover the adjudication process. It's kind of a three-phase process, okay? The first phase is culminates with this public meeting tonight, step number 4, okay? The petition was made, actually the general adjudication started, like I said, back in 1936. We've published notice, we sent out summons, served summons, and we're having the public meeting. The next step, and I'm going to go into a lot greater detail on these next steps, so you guys in a different slide, so don't worry if I kind of just brush through these. Next step will be the claim submission process, the claim evaluation process, and then our submitting our recommendation to the court. So that's kind of like the overview. Now I'm going to get into the weeds here in the next few slides. So don't worry if you didn't understand what I just said, okay? Because I'm going to cover these steps. You're going to know exactly what you're going to need to do in the next few days, all right? So let's talk about filing your water user's claim, okay? In about a week or so, I think August 24th, I want to say, is when we're looking at sending these out. We are going to send out notice to file claims, and it will be so if you receive the summons and the notice to attend this meeting tonight, you'll receive that notice as well, all right, notice to file claims. And you'll ask, well, what the heck's in that? What does that mean? What is a notice to file claims? How are we supposed to file a claim? Well, in this notice, for people who are an owner of water right owner of record, they will receive a water right or a claim that's already filled out. So you ask, well, what's a water right of record? Upstairs in our offices, we have a big file room. These are water rights that we have on our records, people who have appropriated water rights or who have even filed diligence claims to bring those claims onto our records. So we have, and they have little numbers. In this case, they're all 57- something, 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 okay? So A lot of those, all of those water rights that we have in this area, I think there's about 100 of them, water rights of record. We will send those out, and the claim will already be filled out. All you've got to do is sign it and send it back to us, or bring it in, or you can file it in court. For the rest of you who are maybe just property owners, you'll receive a notice to file claims, and you'll have a blank claim form. So let's say, for instance, you have a well that was drilled in 1934, and you have no water right for it, and you need to file a claim. Well, you use this form to fill that out and provide the evidence that, yes, this well was drilled in 1934. It's a pre-statutory right, and it needs to be recognized. Now, that might concern some of you, but honestly, if you just come in, we'll help you fill out the claim. There's no filing fee or anything. We'll take you from point A to point B, West Coast to East Coast, so we'll walk you through it. You have, from the time of that notice, when the notice is given, when the notice is mailed, you have 90 days to file the claim. So don't sit on the laurels and wait for that 90-day period to expire. You need to file your claim. If you need a little bit more time, you can simply request that, and the state engineer is authorized by statute to give an extension of 30 days, but you have to request it within that initial 90 days. If you fail to file a claim within that time frame, you're barred, meaning you can no longer file a claim. If you have a water right of record and you fail to file a claim on that water right of record, it gets published in what's called, well, let me back up just a little bit. You will be barred, all right? So this 90-day time frame is really important for you to act. And if you have questions and you just don't know how to proceed, call us up. We'll walk you through it. We'll help you fill out the form. That's what we do, okay? When those claims are sent to us, we then go and we investigate the claims. We evaluate them, okay? We'll receive a claim in our office. Then members of my teams will come out and try to meet with the claimant to look at the well, if it's claiming a pre-statutory use, or in other words, if it's claiming that it was used prior to this 1935 date for underground water, or 1903, we'll make a determination whether the facts presented in the claim warrant that, all right? And then those claims get compiled, and we'll map them, and we'll send you what our determination is going to be. But let's kind of talk about what happens if you fail to file a claim, all right? So if you're just a property owner, you have no water right to claim, you don't have to do anything. Don't worry about it, okay? If you are someone who is trying to file a claim, you need to file that claim within 90 days. Otherwise, if you're a water right owner of record, that water right will go on this thing called the list of unclaimed rights. And so we have all those, remember that 100 water rights of record that we have upstairs that are in this little area, this subdivision. If people fail to file a claim on it, those will go on a list. And then we send notice of that list to everyone who received the notice to come tonight, all right? And then people will have a public meeting, so we'll publish this list. We'll have another public meeting like this. It's usually attended by about 2 people. To explain the list of unclaimed rights. And then people have about 90, or not about, people have 90 days from the time the list of unclaimed rights was published to file an objection, okay? Now, what does that mean? That sounds complicated. We've gone through great effort to make it easy. You need to file an objection. There's a form that the court has developed. We'll give you links to how to file it. And you need to file a claim at that time with the court as well as with the state engineer. So let's say you just get too busy, or there's some extenuating circumstances, you fail to file a claim within 90 days, your right of record ends up on the list of unclaimed rights. You simply file an objection, file a claim with it, and we usually don't oppose those, all right? There's very few instances where we have opposed. I'm not sure if we have ever opposed. We might if someone abuses it, but for the most part, we want people to file claims. But we want people to act within a certain time frame as well. We're obligated to resolve that objection before the court can issue a decree. Again, we typically just tell the court, hey, we have no opposition to them filing their claim, and we allow you to file it, and it gets removed off the list of unclaimed rights, okay? And then the court will issue a decree that in essence says, anyone who failed to file a claim is barred from asserting that claim from here on forward. So if you were one of these guys that had one of these grandfathered rights, an old diligence claim, a pre-statutory right, you couldn't assert that anymore. The court decree cuts you off. If you are someone who had a water right on this list of unclaimed rights, the court decrees that those have been abandoned, okay? So it's pretty severe penalties if you just don't participate, if you do in fact have a water right to claim. So let's talk about the proposed determination. You recall, people have filed claims, my staff is going out, they're looking at them, and what we do is we make an evaluation and then we make a recommendation in a court. And we compile all those recommendations into one book called the proposed determination, and we file that with the court. And when we file that with the court, we send out notice to people who have filed a claim. So if you haven't filed a claim, you won't receive notice of this except for in the newspaper maybe. And we'll have a public meeting, again, explaining what the proposed determination is. And similar to the list of unclaimed rights, you have 90 days in which to file an objection. So let's say you file your claim, you claim 50 acres of irrigation, my team comes out and they map your lawn or your field or whatever, and we only find 30 acres of irrigation. And we make a recommendation to the court, hey, this is a right for 30 acres of irrigation. And you say, Boulder Dash, I'm going to file an objection. You object to this, say, no, I do have 50 acres. They just failed to miss this 20 acres of irrigation somewhere over here. Usually it's a lot more nuanced than that, but that's kind of the gist of it, right? And so yeah, you can file the objection. Again, we have to resolve those objections. If it's a mistake, we admit the mistake, we petition the court to amend the proposed determination, and we all drive on. If it's something that we don't agree with, we may choose to litigate it, okay? Which means we litigate it before the court. Your attorneys, our attorneys, will go to court and we'll fight over facts and conclusions of law until either the court dismisses it or the objector withdraws their objection. Because we can't do anything, we can't get a decree until those objections are resolved. And that's the ultimate objective of this, is to decree those rights in the proposed determination. So that's the ultimate goal. And the decree will, in essence, confirm those water rights that are included in the proposed determination. Sometimes people will file claims for rights that have long since been abandoned. You know, their water right, haven't been using their water right for 20 years, but they'll still file a claim in hopes that we'll still recognize it. We will recommend those rights to be disallowed. In essence, the court will forfeit those rights because of non-use. And that would be our recommendation. So, and when the court issues that decree, it decrees those forfeited, as well as recognizes those water rights that we've recommended in the proposed determination. So, Templedale, that's a typo. This is wrong, okay? I'm going to correct that before I post it on the internet. I should say Willow Creek. I always forget that. But this is correct. The map's actually right. That's the boundary map for this adjudication. You received a similar type map on your summons. All those purple little dots, those represent points of diversion. Remember, that's where the water's coming from, for those water rights of record. There's roughly 109 of those water rights of record that we have within this area. Most of them are wells and underground. And again, I said, you know, we sent out 12,000 notices, and either people aren't that worried or they just don't have so much to participate. Again, it's pretty common. There's only 100 water rights of record, so it's understandable that people just say, I have nothing to claim and no need to participate further. Issues and anticipated timeline. So one thing about our water rights of record upstairs is that, you know, people who own water rights, let's say you appropriate a water right for your house. This is maybe back in the 40s. And then you sell your house. And the new owner comes in and acquires title to that house. They obviously update title with the county recorder's office. However, the water right associated with that house, those records don't automatically change, you know, because they're not obligated to file. Our records aren't linked with the county recorders. So often what is the case is we have out-of-date ownership records on these water rights, okay? And that can be resolved. It can be resolved through what's called a process called a report of conveyance, which is a completely separate process. The important thing for you to understand is you may receive a claim for a water right on your property that's in someone else's name. And if you want, you can line out their name and just put your name and contact information in and file that. We're not worried about titles as much as we are about defining the water right. Title can always be updated later, so there's no rush to do that, but we do encourage people to update their ownership records with our office so that if they ever needed to renovate their well or drill a new well or sell their water right, whatever they wanted to do, they'd be able to do that a little bit easier. The other issue is the location of no proof required. Sometimes we call these NPRs. So back during the World War II, there was kind of a lack of qualified professionals to file water right proofs. So when you file water right, when you want a water right, you'd go and you'd apply for it at the state engineer's office, and they'd say, all right, you have an application, it's been approved. In 7 years, you've got to file proof showing that you've put it to beneficial use. So that means if you have filed a water right for a house, you've got to show proof that you've built that house and you're using that in 7 years. Well, that proof is required to be filed by an engineer or a surveyor, a qualified professional. Well, in the 40s, there wasn't a lot of those guys kicking around because they're all fighting Nazis, right? And so what the state legislature said, hey, for small amounts of water, we're just going to waive that requirement for proof, which was great, and it helped a lot of people out. The problem with it is, without having to file proof, sometimes the location for where those wells are shown on our database is inaccurate because they didn't have a proof professional actually pinning it down to the correct location later on. So sometimes, and afterwards this meeting, I'll show you our interface that shows a map of where these wells are located that we have record of. And you can see whether you have one near your property. But sometimes these are in a completely off-the-wall location, like in a doghouse or in the middle of the street, somewhere that you wouldn't expect them to be. And that's sometimes because of, when they didn't file proof, and so they just had the location that they kind of scaled off an old quad map to figure out what their location would be. And so don't take those locations that you see on our database for granted. They may be off by several hundred feet in some instances. All right, the anticipated timeline. August 24th, we'll send notice to file claims. That's when that 90-day claim filing period time frame starts. You have 90 days to file a claim. November 22nd would be the last day that you can file a claim, so that's the conclusion of that 90-day period. And we'll be investigating claims throughout that period. We won't just start in November. We'll start when they start coming in. But in March of 2019, we'll hopefully have the list of unclaimed rights ready to be published. These are kind of rough dates. It really depends on how complicated things are. But usually the list of unclaimed rights is pretty easy to get because it's simply compiled the people who fail to file claims. There's not a whole lot of investigation that needs to occur on that. Then you'll have the 90-day objection period for that list of unclaimed rights, which will run until June. And then around February of 2020, and that's when we're kind of looking to file the proposed determination. That's kind of even a rougher time frame because depending on how complicated these water rights are, it may be pushed to the left or to the right a little bit further down the road. But it's going to be after February of 2020, I can guarantee that much. And then around 90 days after, whenever we publish that, you'll have that 90-day objection period to say, hey, I don't like what the state engineer said in the proposed determination. I actually irrigating this much, or I have this many stock animals, or whatever, right? You have the opportunity to file an objection, and then we would be forced to either negotiate a settlement with you or litigate it. Well, I lose my water right. This is the common theme we often get. If you're using your water right in conformance with the records we have on file, meaning you're actively putting it beneficial use, you have nothing to worry about as long as you file a claim. Individuals using water without a water right of record are required to submit a claim, otherwise they risk being barred, again, from filing that claim later on. And then if you haven't used your water in 7 years, all or a portion of it might be recommended to be disallowed, was the term we use, but ultimately decreed to be forfeited by the court. So if you have a water right for 100 acres of irrigation, and for the last 20 years you've only used 50 acres of irrigation, we'll just recommend the right be recognized for 50 acres, meaning the balance, the other 50 acres, is in essence been forfeited through non-use. Okay. Who can I contact? That's me at the top. That's my deputy there, second down, and then Ashley Ostruff. She'll be the team leader, but we have a bunch of different individuals that you may come in contact if you walk in and need a claim filed. You don't need to schedule an appointment, but it's easier if you do, 'cause that way we can do some research on your claim or your area before you get in, and kind of rather than having you sit and watch us as we kind of monkey around with the computer trying to figure out where you're at and what the basis of your water right is. And with that, this may be the first presentation I have ever given where no one has asked a question throughout, so pat yourself on the back now. Are there any questions, seriously? Is there any confusion out there? Yes, ma'am.
How come I received 4 letters in the mail?
How come so she received 4 letters in the mail. She's asked why. I don't know exactly. I can guess. If you own multiple properties within this area, we went to the county recorder's office, identified the property owners, and we sent out notice to whoever is listed as a property owner within that area. So that's guess number 1. Other than that, I'm not sure. I'd have to go back and look at my list and see why that is the case. Apologize if that was weird.
Curious about it.
Were they all addressed to you, specific your name? Okay, yeah, I'm not sure.
I had a neighbor that received 2 or 3 of them.
Yeah, I'm not sure. We'd have to go look at it. We try to filter those out to make sure that we're only sending one out. But it could also, and keep in mind that we're doing multiple of these at the same time. So sometimes you'll receive a notice for a different subdivision, but you're saying they're all the exact same. Okay. Yeah, I'm not sure. I'll have to get with you and see what your name is and do some research. And we try to filter those out, any duplicate addresses, but dealing with 12,000 names on a spreadsheet can make you want to kill yourself sometimes. And so, soul crushing work, and sometimes we miss those. So that's probably why. Yes, sir.
To make sure that they're doing that on my behalf. Even if they do, is there a chance because I haven't used up my share ever on my property that it can be rescinded?
Those are great questions. So let me repeat it for the benefit of everyone. He has shares in an irrigation company. He hasn't really used those shares on his property for over 7 years. He asked a couple questions. First, what is his obligation in this process? Is the company going to participate on my behalf? And am I going to lose that because I haven't been using it, even though it's a share? So let me start that off. First of all, the company should be participating on the behalf of their shareholders. They're the owner of the water rights. Now, does that mean you can just cool, peace, I'm out, right? No, you should probably make sure that they're tracking this stuff. Most irrigation companies we have a working relationship with, and so there aren't very many that aren't knowledgeable, that don't know this isn't coming down the pike. The second question is, well, I think I answered the second question. The irrigation company should do this for you, and you should have a vested interest. Third question, can my share be rescinded or lost to forfeiture? And the answer is yes, actually. Even though you're a shareholder, there's the law in the book that says if a shareholder fails to use his water, because then we'll simply reduce the company's water right by that commensurate amount. And then the company will come back to the shareholder and say, hey, because you caused us to lose this, we are reducing your share, or we're getting rid of it, or reducing the value of it, whatever the case may be. They have the power, but that's really within the company's bylaws as to how that works. To us, we're just looking at the water right and saying, they have this much stuff being irrigated, that's their right. And now the irrigation company is going to say, hey, they said this is our right, but I know we have shares for this much. Well, who's not using theirs? And they're like, oh, these guys aren't using theirs, so we're going to axe their shares. So that's kind of the risk you run.
Quick follow-up.
Sure.
I want to put a sprinkling system in my yard like this coming spring. If I do that and I tap into, the irrigation company can't even tell me if they say it costs $4,000 to tap into the system. I don't know if that means like a municipal system. I imagine not. I imagine they're controlling my water. It's very confusing. But anyway, if I manage to get through all that and get a sprinkling system set up in my yard, will then I be grandfathered in?
So that's a tricky question. So the question is, hey, if I get an irrigation system up and running, will I be grandfathered in? Will it be? So this is the delicate answer I've got to give on that, all right? If we come out and we observe beneficial use associated with the share or the water right, we're not going to look any further, okay? We're going to say, yep, it's being used. We're not going to kind of do Sherlock Holmes of water rights and figure out whether you've been using it the previous years or not. Because in truth, our desire is for people to use their water, okay? But if we come out and we say, and we see that you're not using it, and then you say, well, I'm going to put an irrigation system in here in the next few months, hey, it's cows out of the barn at that point. You know, we can't turn back time and not look at that and say it hasn't been used. So that should give you kind of the direction that, you know, you ever have a presentation where someone stomps on the ground, that means pay attention. It's like, hey, if we come out and the water's being put to beneficial use, you're good to go, right? So remember that. All right. Yes, sir, and I'll get back to you, man.
In regards to the question, having developed a few subdivisions around the Salt Lake Valley, there's all kinds of questions that this raises. In his particular case, the fact that he has been told if he wants to tap into that system, it costs $4,000. He has that right because they've already told him that.
Okay.
Right?
So let me just rephrase. So the gentleman up front is making the case that because this irrigation company, which is a private company, has told him that he can tap into the system for $4,000, he has that right to do so. I think what we're conflating the concept of right and privilege, right? It's not for me to say what is the right of the irrigation company to do or not do. So I'm kind of backed off a little bit, and I'm looking at the water rights. Now, how the irrigation company interacts with their own shareholders, you know, that's not really my lane. It's not my purview. They have a contractual relationship, and however that operates within the bylaws of that company, I guess that's how that operates.
I put in an irrigation system out in Cottonwood Heights that took care of a lot of people.
Mm-hmm.
And he would fit right in that, and the water is already there, and it's in a pipe, and he needs to pay the fee to have gone to that pipe, but the water's always going to be there. So how do you handle that? He doesn't still have it, the right?
So the question is, the water's there, he can always hook into it,
right.
So how do we handle that? You know, does he still lose it? What I think you need to think of is that beneficial use is the basis, limit, and measure of a water right. So if we come out and we look at an irrigation company's net irrigation, we're going to say, all right, this irrigation company has a water right for 1,000 acres. They are irrigating 800 acres. And that's all we see, right? It doesn't take into account, well, you have these other shareholders who have the potential to hook in and irrigate those other 200 acres. It's just we're looking at what has been used in the last 7 years, okay? And so I'm not sure if that answers your question. It probably doesn't answer it to your satisfaction,
well, this was done 40 years ago.
Okay.
And I can tell you where it went because I was the one
Well, maybe we can talk offline a little bit and see if we can find a solution for this gentleman. Yes, ma'am.
I'm understanding you said everyone who files a claim you will contact and come out to their property, right?
Yeah, so our question is, everyone who files a claim will contact and come out to the property. Yeah, that's part of the process.
Frame for that.
The time frame is when you file a claim. So we got 20 of these going on right now. And so as claims come in, we're kind of prioritizing the ones that need to get done. So I don't have an exact time frame. It should be within a few months or weeks.
Contact this by mail?
What we prefer to do, how we prefer to contact is if you put your phone number or your email address on the claim, that is super helpful because then we'll call you up and schedule an appointment to come out. Because really, we're not trying to skulk around under cover of dark trying to figure out if people have water they're using, right? It's a lot easier if we go out there and the people are there and say, here's my well. This is what we're irrigating, you know. So we really, it's to our advantage to contact water users. Yes, sir.
In order to facilitate an irrigation company's, let's call it an audit of rights and
Okay.
shares, it's almost impossible for somebody to come out and check on Tuesday because the water usage is distributed per day, so everybody's not trying to get water on the same day. So would it be beneficial for an irrigation company to do their own audit and have it on paper so that you can see how much is being used on which days by which water shareholders, and then submit that as a whole package?
That's a great question. Let me address that. So this question, so I've been talking a lot about individual water users, where we come out and we'll see your stuff in one day. Irrigation companies, vastly more complex, right? And as the gentleman mentioned, they have turn schedules, they're irrigating on certain days. Really, that becomes more of a process of figuring it out. And sometimes we have irrigation companies who do not welcome us into their home, and it's us trying to figure it out. And then we say, all right, this is what we've figured out. And they said, oh, that's a bunch of horse crap. You know, you missed all of this stuff. And they're like, well, you could have just told us where this is, right? So what we really appreciate is if the irrigation company, we work with the irrigation company to identify the lots for which there are shares, and we can just say, all right, that's being irrigated. So yeah, would it be awesome if an irrigation company with their claim submitted a map of everything that was irrigated? Oh, that would be the day, right? I could just die right there. Probably won't happen, but it'd be great if it did, but really what we probably envision is working with the irrigation company to identify and just kind of figure it out as we go along. Because sometimes what will happen is people have privately owned wells as well as share an irrigation company. They'll be irrigating the same acreage. So here's the question, who gets the acreage, right? The well guy or the irrigation company? Well, that's a good question. And sometimes we've got to work with the shareholder and the irrigation company to figure that out. In truth, they can both have it, but the sole supply is what gets divided between the two. And that's like water rights 201. So we'll save that for that course for another day. That's graduate level water rights. Are there any other questions? Oh, yep.
What year was the use it or lose it law in effect?
So Utah, is actually, his question is, what year was the use it or lose it law implemented? And it was implemented in 1903. It's always been a part of Utah water law. As a matter of fact, like I said, all Western states have some version of that. Because the fear was you would get some wealthy entity who would go and appropriate large, vast acres of land and water, and then become the monopoly and where you'd have to go to get their water. And so the legislature just wanted to avoid that and wanted to make sure that water is being put to its most beneficial use. Did you have a follow-up question to that? All right.
Once the water right is taken away from persons, or the amount of water that they are allowed to use is taken away, who gets it?
That's a great question. So his question is, when a water right is recommended to be disallowed or forfeited and is taken away ostensibly from the water user, who gets it? No one gets it. That water is being used by someone downstream, right? It's already being used. So really what happens is you have this big stack of, you think of paper water rights, right? And you just remove, and you have maybe this much wet water, and only part of the stack is actually getting wet water. Well, you take out one of these pieces of paper out of the stack, and it moves one piece of paper up into the wet water zone, and now finally they're getting water. So the water right doesn't go to anyone. It just gets decreed forfeited, stays up in our record room. We don't sell it, we don't own it. Doesn't get reappropriated. It simply just goes to the next person to satisfy the needs of the rights subsequent in line. Hold on, there was a question over here. Yes, ma'am.
Is the East Jordan Irrigation Company one of the companies that you're working with or not?
Is the East Jordan Irrigation Company one of the companies we're working with or not? The answer is yes, we are working with them. You betcha. Do you have another question?
Richard's Irrigation.
Richard's Irrigation?
Yep.
You're asking whether we're working with them or not? I do not. I'm not that. So I have 20 of these subdivisions. So my team leader might know whether we're working with them or not, but we can certainly talk offline and make sure that we got their contact information. And
You will have, because it's one of the best systems that's ever been put in.
okay. It's a gold star system then.
1/11th of Little Cottonwood Creek water.
Oh, then yeah, we'll definitely be. We'll definitely be working with them. Great. Glad to hear it. Other questions? All right, hey, I'm just going to look at my email really quick and see. Oh, was there someone over here? And get Ashley's point. And is it behind the column? Oh, yes, sir.
Okay, we have property down in Santa Fe County. Is this just for Willow Creek?
Yeah, so Right. So I got an email today asking that similar question that, hey, I've got this water right down in Sanpete County. Do I have to file a claim on it? No, this is only for water rights within that boundary of that map.
We got the letter because we have a water right.
Or you own property in that area.
Okay, we do own property, but it's city water or whatever it is.
Then you probably needn't worry about participating further.
Go home and have dessert.
You can go to home, have dessert. You could have gone home an hour ago and had plenty of dessert. Sorry for wasting your time. Let me just double check, see if there's any emails coming along. I don't see any questions. It's quiet on the online front as well. So what I usually like to do after this is open up our website and go through our database, so through our aerial imagery interface. There's some cool tools on there in case you want to, if you not sure if you have a water right or if the well in your yard has a water right associated with it. We can look at that and you can access it. And unless there's any other questions for the benefit of the group, I'll go ahead and transition to that part of the program. Okay. Just bear with me for a second here. I'm just going to fix this. Go ahead.
I just thought of one here.
Yeah.
Personal, but Sandy City sent out a notice that if your backflow preventer was not up to date or didn't get certified within a certain time frame, you would forfeit your water.
What?
Because they don't want it mixing with the culinary.
All right, so his question is, or his statement is that Sandy City sent out a notice saying if you fail to update your backflow prevention valve, you forfeit your water right. What I suspect they meant is if you have shares in their company, they can do whatever they want.
They don't own the company. It's owned by Dimpleville.
Yeah, so, but did it come from the company or from Sandy or? So they can't forfeit a right, right? What they can do is they can shut off your culinary service. They can do that. And if they are majority stakeholders, shareholders in the company, they can probably influence the board to say your shares have been forfeited, I suppose. But they can't do anything with a base water right. Okay, that's me. It's not them. So I'm not sure what, we can look at that later. If you have it, we can look at it later, and maybe I can provide a little bit more clarity to it. But that doesn't sound like something that makes a whole lot of sense to me.
They have to do that because if you mix it with the culinary, you could cause other people to.
Yeah, there's certain good reasons. There's certain good reasons for making sure your backflow prevention valve is operational. But as far as what means they have to enforce that, I'm sure are limited, and I'm sure hopefully they've consulted with competent legal counsel when they drafted that letter. So let's go to the home page here. All right, so this is the Utah Division of Water Rights homepage. Let's see if I go a little bit bigger. So on the front of the home screen, if you want to check the status of the adjudication, you go to the adjudication link, okay? And maybe you've already been here because this is where the little web interface showed you go watch our cartoon, right? So if you go up to this button that says Active Adjudications and select it, you can scroll down to the bottom till you see Willow Creek, right? Down here at the bottom, area 5725. And there's a little map, so if you click on the map, it'll bring up a map interface that will show all the points of diversion within the Willow Creek book. And so these purple lines you see, these are other subdivision boundaries. So you see all those purple lines, those are all the books we're currently working through right now. But we're just going to focus in on Dimpledale right here. So this has some cool features, all right? This little interface. I'm going to show them some of you. So let's say you're not very good at kind of navigating via aerial imagery. We can go over here. So I'm scrolling over to here, okay? Let me minimize that so the whole thing fits on the, there we go. this has a little search tab. So these are a couple different tools. If you can turn on other points of diversion. Right now, it's got all the points of diversion in the adjudication. You can always, if there's too much, you can turn them off. We'll just leave them on for now. Let's say you just can't navigate via aerial imagery and you want to do an address, all right? Whose address should I use?
1632 East.
1632 East.
11400 South.
11400
Yes.
South. And I know you're not Salt Lake City, but that just does it just as quick. So let me turn this off. And was 1632?
1632.
Sorry. Let me get rid of this one now. Zoom in. Okay, so at your house, right? Hopefully. We'll turn the points of diversion back on. I don't see anything in your immediate vicinity.
That's right. Yeah.
So you kind of go out, you start to see them coming online. There's 57, 78, 07. So what this says is you don't have any points of diversion, any wells that we know about. Okay, that doesn't mean if you have a well that you don't have a water right. It just means we don't have it on our records. But this is kind of a good indicator. Is there anyone else want to give it a shot? Any other addresses want me to look at? Okay, other features on this, like I said, there's these different layers. You know, you can play around. You can mess around with whatever you want. You can add, you can do different maps if you want to do a topo map, or if you're just a big hunter or fisher, you got topo maps for the entire state of Utah at your dispense right here, right? So, kind of some cool features. Let me go back to the aerial imagery. Tools. If you need to measure something, you can measure them here, do an area. So if you want to know how many acres of irrigation you're irrigating, this is one free feature you can use to do that, okay? Now let's say you come upon a water right. I'm just going to look at 57807 right now, okay? So you say, hey, that's on my property. I wonder what that's all about. You select the icon. So the red icons indicate underground wells. There's some blue icons that would be surface diversions, all right? So the red ones are underground, blue are surface. You can select on that, and then there's this hyperlink up here with the number right there. You select that, and this will come up with our database of what water or what information we have for this water right, and we'll let it load a little bit. Okay, so this shows our records, all right? So in this case, this water right is owned by Gerald W. Peterson. Has a priority date of 1971, so that's when he applied to drill a well in his property. Its uses are down here. So you come down here. It's authorized to use for 0.48 acres of irrigation, 10 ELUs of stock water, and ELU is an equivalent livestock, so think equivalent livestock units, so think cow, horse, but if you have a bunch of chickens, they can equal 1 horse, so we just use ELUs, okay? So 10 stock and 3 EDUs, or 3 equivalent domestic units, 3 houses is in essence what this water right is authorized for. Right here, this link right here, that is how we describe points of diversion using the public land survey system. Really quickly, this point of diversion is located north 1,379 feet, east 209 feet from the south quarter corner of Section 21, Township 3 South, Range 1 East, Salt Lake Basin Meridian. Again, nothing secret squirrel about that. It's just you got to figure out what that is. Just in essence, it's a big grid over the state of Utah, and you can figure out where it's located using that grid.
Can you see the irrigation companies look right
Sure.
in this database?
Yeah. So what I'm going to do is I'm going to go back to the home page because I don't know exactly where the irrigation company's rights are. And so if you go over here, you see this icon up here, this button that says search. If you select that, you can search for the name of a person or an entity. In this case, we'll search for owner's name. What irrigation company are you looking for? Any?
Let's just do Dimple though.
Okay. And that will come up with an alphabetical listing. And nothing really comes up for Dimple Dell. Must be under a different name.
Sandy City.
So Sandy City.
Yeah.
Maybe it is.
Yeah, they're the ones bottom.
Well, then it's probably Sandy City then. Yeah, and they got plenty of water rights. One thing I'll add, just to spark the ire of those who haven't already had their ire sparked this evening, is that public water suppliers a few years back, about 10 years ago, were successful in changing the law to make them immune from forfeiture. So their water rights are preserved from allegations in the theory that they've got to acquire water rights for future use, and so they've got to have these water rights in kind of in place as the communities develop. So for better or for worse, that's as far as I will go as giving it opining on whether that's a good thing or a bad thing. But so if they own irrigation, if they own shares in an irrigation company, same thing there. Those shares are preserved. And so they can essentially have a lot of shares in irrigation company, and even if there's not irrigation associated with those shares get preserved. So sometimes irrigation companies like to have their water rights or their shares in what public water suppliers because they're immune from that, whereas irrigation companies by themselves are not. So.
How do the irrigation companies profit off the water shares? Because I can tell they're super valuable. They're like.
How do irrigation companies profit off of shares?
They're always trying to buy our shares back, like very aggressively.
Well, generally in the Salt Lake Valley, water is pretty expensive because it's closed to new appropriations. So there's a certain number of water rights in the valley, no more. You can't make new ones. And so when you limit the number, obviously you limit the supply, the price and the demand is up here, the price goes high. And so public water suppliers, municipalities, Salt Lake City, Sandy City, all these agencies are trying to preserve and the ability to expand and grow. And so they make this demand for water, and they've got to acquire these water rights. So often what has been the case in Salt Lake Valley is that the municipalities become the major shareholder in an irrigation company, and they are less interested in maintaining those ditches and that infrastructure because that takes money and time. And what they'd rather do is just hold on to the water and use it to satisfy their municipal purposes. And so that's one way that demand and price kind of gets driven by that. And then you have other areas that maybe are expanding on the west side of Salt Lake or even down in the Utah Valley, depending on how you can move water around. There are new communities that are looking for water. We continue to grow as a state, and even in Salt Lake Valley, there's still some growth left, and so there's that demand. And so you see this constant overturn from agricultural to municipal, and you see that big time in Weber, Davis County. You see it in Salt Lake County. It's becoming more and more urbanized as less farmers, and they simply decide they're done farming. Figure they'd rather grow a subdivision instead of alfalfa and sell their property and the water rights with them.
Okay. So does the municipality buy water rights from the irrigation company?
You bet.
Okay.
Yeah, they usually acquire shares.
Yeah.
Yeah.
They have a stock certificate, don't you?
They do.
Sure you do.
Yeah.
Yeah. So yeah, so water rights and shares are valuable. One thing about shares, well, water rights you could sell them to whomever you want to because you own the water rights. Shares, not so much, right? Because they have to be operated under the bylaws of the respective company. So some companies have put prohibitions on people selling shares or divesting their property from those shares and selling them off. So one thing to keep in mind before you take that and try to sell it to someone. You can always sell it and try to get their money, but I guess whether they can use it or not is a whole different ball wax. Yes, sir.
Most of these companies, like the one that I set up, Cottonwood Heights, they actually will take, and you cannot sell that water right. It stays with the property that you own.
Yeah.
So you cannot sell it.
And that's pretty common. He's saying, a lot of irrigation companies will set up the company bylaws in such a way that the shares stay with the property. And that's how, I live in Huntsville, and my property has shares, and I cannot divest myself of those. I can't divest the property of the shares. It's just, that's the bylaws of the company. So
I'm new, so we just bought a house
Welcome then.
Yeah.
Welcome to the craziness.
Now I'm really confused.
Yeah.
So, my property's in Pepperwood, the Pepperwood community.
Okay.
And I've got a natural spring on the property. That's why I assumed I was here.
Okay.
It's not a well, it's not tapped. So, a lot of stuff you're talking about is water usage.
Mm-hmm.
But I don't understand the water rights in my case. Do I do that?
So so you have for benefit of everyone, he has that natural spring on his property, and he doesn't understand whether he needs a water right or not. The bottom line is, if you use the water, you need a water right to use the water. Okay. Now, if you're just letting the spring kind of gurgle past and go on down its merry way, you don't need to do anything. But if you suddenly start to divert that, start applying it to a lawn, doing fish culture or whatever like that, you do, because there are other people who are reliant on that water making its way to the creek and further on down and to divert and other things. So, and we can certainly look at your property and see if there's an existing water right for that. But I don't know if there is. Now, you can't simply, well, I'm going to file a claim and develop one out of thin air. Again, water has to have been used prior to 1903 for surface waters, which is what a spring would be. So any claim you make would either have to be based on a pre-statutory right or an existing water right application that had been perfected. But I know that's all like gobbledygook, right? So if you come to us, we'll figure out whether you have anything, okay?
In a case of that kind, it sounds to me like in this valley, if someone's selling a house, they're going to tell you there's a spring on it as part of the sale price.
Well, yeah, if someone sells you a house and as part of the sale price says there's a spring on it, sure. Now, if it's a spring with water rights, that just bumps it up a little bit more, right? But a spring by itself is pretty cool. But a spring with water rights, now we're talking, right?
Because if it's animals are drinking the water out of there, he's using it.
Yeah, if animals are drinking out of it,
Yeah,
if you're animals, I mean, I'm not worried if your dog's drinking out of the spring or not. But and really, honestly, we're not the enforcement wing. The state engineer has one enforcement officer. He lives in Cedar City, and really what he does, if people rat out their neighbor or something like that, he goes and investigates the enforcement and may file an enforcement action. Those are pretty rare. Really what we try to get is compliance, and so if someone's using water illegally, it's usually because they don't understand. Sometimes there's some nefarious motives, but we are not them. We will simply say whether you have a right or don't have a water right, and we make that recommendation to the court. Anything else?
One question, then I'm through.
Okay.
I have 17 shares of water in an irrigation company that I don't know the status of. I just know that I have the certificates.
Okay.
And the name of the irrigation company is one that is in Cottonwood Heights with the name of Greenwood Irrigation Company.
I am not familiar with Greenwood Irrigation Company, but I will tell you right now, I am not a native Salt Lakean either. So, but we do have John Bream, who has worked in the Utah Lake Jordan River Regional Office. He may be a little bit more familiar. I see a Greenwood water right here. I'm not sure if this is the irrigation company or not. Looks like it's a decreed water right, so it probably is.
In Cottonwood Heights?
It's out of Little Cottonwood. We can see where it is.
That's where it would be.
We can map it and see where it's coming out of. It's coming out of a bunch of trees, so obviously. Let's see. Yeah, so that's Little Cottonwood Canyon. So that's its point of diversion. That is Little Cottonwood Canyon, right? Yeah. But yeah, I suspect that's the irrigation company. What I know about it, I don't know whether if we go to our website, we should have a company page. Let me see. I'm not not sure how open that is or not. We can find out about it. We may have some records on the company. Just talk to us. Any other questions? All right, good talk. Thanks for coming out, and let me know if you guys have any other issues. We'll help you out. No applause necessary.